So my name is Mike Kofahl. I'm a staff lawyer here at East Coast Environmental Law, and I'm joined by Richelle Martin, my colleague and another staff lawyer.
Hi everyone.
Um, we're going to do a little lunch and learn today, and thought we'd focus on some different aspects of wetland protection, stewardship, kind of focusing on Nova Scotia law, but drawing in some other examples from other jurisdictions potentially. So I'm going to start with my presentation. All right, well, let's get into it. So I actually want to start with a land acknowledgement. I'm joining today from Unama'ki, which is part of the traditional unceded and unsurrendered territory of the Mi'kmaq. Um, these are part of the territories of the Mi'kmaq that are covered by treaties of peace and friendship that were entered into with the British beginning in the early 18th century. East Coast Environmental Law works throughout this region, and so we work. Our work in Atlantic Canada also covers the unceded and traditional territories of the Passamaquoddy and Wolastoqey, the Innu and Inuit, and historically the Beothuk as well, covering those four provinces of in the region. And I just want to acknowledge that I will be primarily talking about settler, colonial, crown law, so provincial, municipal law in particular. But I think it's really important to recognize that prior to colonialization, there were a number of systems of law by Indigenous nations throughout this region that really govern their relationship with their land and the use of the land. And it's really important to recognize. And I'll be talking a little bit later about some of the interactions between colonists and settlers in some of the coastal wetlands. So just recognizing that there is space for all of those different legal systems in this space we now call Canada. I also want to introduce briefly East Coast Environmental Law. We are a nonprofit environmental law charity. Obviously, we work throughout Atlantic Canada. And our vision is really a future where we have laws and legal systems, including colonial and Indigenous legal systems, that protect ecological health and promote environmental and climate justice throughout the region. We advocate for progressive environmental laws and policies, and we do our work through various kinds of ways. So, for example, we do legal advocacy, we engage in law reform, we provide legal education, resources and materials, and you can check out our website, www.ecelaw.ca. And we also share our legal skills to support individuals, communities, and organizations, including working on projects, conducting legal research, and yeah, just working together with folks in the region. So I'm going to be talking a little bit about the general protections that are available under the law for wetlands, and I'll talk also a little bit about policy. And I'll focus on discharges into the environment. I'll focus on wetland alterations, environmental assessments, and I'll speak briefly about setbacks and buffers. I'm also going to talk a little bit about municipal bylaw protections that are available, and then I'll dive into some examples of coastal wet law protection and some of the gaps or challenges that remain even for coastal wetlands. So a good starting place is the Environment Act. And the Environment Act defines wetlands. So wetlands under the Act include marshes, swamps, fens, and bogs. And they make the Minister of Environment and Climate Change the responsible minister, and the Department of Environment, the primary provincial department responsible for managing wetlands, particularly under this Act. And you'll notice we'll focus on provincial law because there isn't a huge direct federal role, in part because the way that the Constitution divides jurisdiction between the federal and provincial government. So the provinces have an outsized or a large role in provincial protection of wetlands. So one of the ways that the Environment Act protects wetlands and the environment more generally is setting out these two prohibitions against the releases of or release of certain substances. So these are two basically identical provisions in the Environment Act. The first prohibits any person from releasing or allowing the release of a substance into the environment if that substance is released in a way that could cause an adverse effect. And the Environment Act specifically defines an adverse effect as any effect that impairs or damages the environment or that changes the environment in a way that negatively affects aspects of human health. The second prohibition similarly prohibits every person from making that sort of release of a substance in the case of an excess of something that's been authorized by an approval or a regulation. So for example, if you're going to release some substance in the environment and you've gotten approval to release that at a rate of 1 liter per minute, and you're releasing it at a 1.5 liters per minute, that is a contravention. And there doesn't have to be a finding that there's actually an adverse effect. And both of these prohibitions are very general, so it's a release of a substance into the environment, but the environment does include wetlands. So indirectly, it is a prohibition of releases of certain substances into wetlands. Another really important feature of the Environment Act regime is the wetland alteration approval process. So the activities designation regulations, which are created under the Act, requires an approval for anyone to alter a wetland or to alter the flow of water on a wetland. And a rehabilitation of a wetland, it also requires this kind of approval. Now, the Environment Act and neither the Environment Act or the regulations actually define what an alteration is, but the department does have a resource that's entitled "So You Need to Alter a Wetland" that essentially says that an alteration includes infilling, draining, flooding, excavation. Basically, if you're taking something out or putting something into a wetland or altering the structure of the wetland, you're altering a wetland. If you get approval to alter a wetland, you have to comply with all the terms and conditions of that approval, and failure to do so is a violation of the Act. Typically, when we hear concerns about wetlands and concerns about or questions about whether a wetland has been altered, a good early step to take is trying to figure out if a approval has actually been issued for a wetland alteration. And the department does make all the approvals available to the public through its online environmental registry. And you can go online, you can type in environmental registry for Nova Scotia into Google, and you can find it pretty easily. There's a landing page. You can make an application for those approvals. I think you can search up to 10 properties in one application, and there's a small fee, I believe $5 or $10, and then you can seek that information. So you can actually find out, has someone gotten an approval or not. And I'm going to talk about the wetland conservation policy in a second here, but I just want to note that one of the things that it does is it guides the wetland alteration process. And the wetland conservation policy actually says that there will be no alterations of certain kinds of wetlands, including wetlands of special significance, except with some exceptions, some minor exceptions. So what is the wetland conservation policy? Well, it's essentially a policy guiding decisions around wetlands in the province that was released about 15 years ago. Important to recognize, it's not law and it can't replace or override legislative requirements, for example, those wetland alteration requirements under the Environment Act and the regulations. One of the key goals of the wetland conservation policy is to prevent the net loss of wetland. So you can make alterations to wetlands, but overall you don't want to lose wetlands in the province. And it does this work through advocating for wetland conservation, guiding wetland protection, and guiding development, including through that wetland alteration process. It also has some really specific and important objectives, and these are the highlighted ones. So no loss of wetlands of special significance, and the prevention of a net loss in area and function of other wetlands. And I'll come back to that function feature later. And so this idea of a wetland of special significance is really important to the kind of core of the policy. And so wetlands of special significance are including wetlands that support threatened or endangered species, um, and wetlands that overlap with a variety of different legally designated sites, including Ramsar sites, provincial wildlife management areas, provincial parks, nature reserves, wilderness areas, or lands owned or protected by a land trust. So pretty significant. Um, Another important wetland of special significance, and the first one that's in the policy, is salt marshes. I will say that back in 2023, in September of 2023, there were some so-called clarifications to the policy that were kind of concerning to us. So the Department of Environment and Climate Change circulated to its staff these clarifications, and they included, specifically were focused on wetlands of special significance designations. So they limited those designations to wetlands that support threatened and endangered species only. And so they now actually exclude vulnerable or special concern listings for those species. They only apply now to the portion of a wetland that actually directly supports species at risk, as determined by qualified experts. And there's some concern there around how often are these qualified experts doing that work, and what actually does the department mean by directly supporting a species at risk versus indirectly supporting a species at risk. And now only the portion of the wetland that actually overlaps all those designated areas, like wildlife management areas and provincial parks, only the portion of the wetland that's actually overlapping with that area is now covered. So for example, if you have a 5-hectare wetland and only 2 hectares of that is in a provincial park, only that 2 hectares of wetland in the provincial park is actually now a wetland of special significance. So I would say these are a narrowing of the scope. It was also concerning that the changes weren't announced publicly through any kind of website or social media or any other kinds of channels. And there doesn't seem to be any publicly available evidence that scientists, experts, communities, indigenous nations were actually consulted before these clarifications were made. And the clarifications are not in writing, so they're not actually contained in the policy itself in writing. So the text of the policy has not changed. So moving on from wetland alterations and the policy, some other mechanisms that are enabled by the law that provide protections for wetland include environmental assessments. So the environmental assessment regulations are also made under the Environment Act, and they require any project to be registered for an assessment if it will disrupt a total of 2 hectares or more of any wetland. This isn't the only way environmental assessments can help protect wetlands. Even if other projects trigger an environmental assessment for other reasons, for example, maybe there's a large withdrawal of water, or it's a pipeline, or a large project that automatically triggers an environmental assessment, the wetland piece can be a really important of that assessment, and that would be where individuals or community members, organizations such as ourselves, would actually highlight the ways that a proponent might contribute to the wetland conservation goals of the province or not contribute to those conservation objectives. And one other kind of general tool that's available is buffers and setbacks. So a buffer is sometimes called a vegetative buffer, and it basically refers to a strip of vegetation or area that's left undisturbed, where certain activities or all activities are restricted. And then a setback is just a separation distance to try to reduce conflict or minimize impacts between a land use or development or an activity and the natural features like a wetland. And so 2 examples in the sewage disposal system standards, which is regulated under the Environment Act, there's a 30-meter horizontal setback from a wetland, from any sewage system part, any part of it. And then under the Forest Act, the Wildlife Habitat and Watercourses Protection Regulation, that is quite a mouthful, requires a buffer zone from forestry operations. And that buffer zone has to be at least 50 has to be at least 20 meters wide along all the boundaries of a wetland. Now, I think it's also really important to think about municipal powers because municipal governments potentially have a wide scope and lots of powers to protect wetlands. So the Municipal Government Act and the Halifax Regional Municipal Charter are the sources of municipal powers. And the most prominent powers given to the municipalities under these two pieces of legislation are the power to create municipal planning strategies and the power to create land use bylaws or other bylaws. And land use bylaws have to be consistent with planning strategies. So municipal planning strategies are basically statements of policy, and they cover all kinds of things, including development and management in the municipality, whether it's private or municipally owned lands. And an MPS can include statements of policy on all kinds of things, including on matters related to the natural environment, which can include identifying, protecting, using, and developing wetlands or other environmentally sensitive areas. So the Municipal Government Act and the Halifax Charter actually explicitly mention wetlands as part of the powers that a municipality has to regulate using a municipal planning strategy. So there's lots of different ways that municipalities have done this. The municipality of the District of Lunenburg, for example, has adopted a land use, or their municipal planning strategy requires a land use bylaw to be adopted in which coastal wetlands will be recognized in a development constraints map. The town of Yarmouth makes it the intention through their municipal planning strategy to establish an environmentally sensitive zone where all kinds of development are prohibited, except for certain activities like wetland conservation projects. So this is actually a potential positive. It's actually encouraging wetland conservation. And the CBRM has a policy that discourages development in environmentally sensitive areas, including wetlands. And municipal planning strategies can dictate kind of the ongoing activities of a municipality more broadly. So, for example, it can not only can it inform municipal decisions around wetlands through zoning or direct development restrictions, it can also do things like advancing stewardship. It can advance or fund or allow for citizen science projects or the study of wetlands and allow for the identification, mapping, or inventorying of wetlands. And they can either do that themselves or they can hire those kinds of activities out. And it can also establish zones, as I mentioned in the examples, where conservation is prioritized or development is prohibited. And you see this photo is of a CBC article, a very recent project where Halifax is actually experimenting with floating wetlands. And that is to deal with excess nutrients that are coming from urban runoff. So this is actually a 2-year study that the municipality is doing with the university at Dalhousie to deal with and to experiment with wetlands. So that's just an example of the kinds of initiatives that a municipality can undertake. There's also land use bylaws. So these are legally binding and enforceable rules that have to be consistent with those planning strategies. And they can be used, for example, to create buffers and setbacks or restrict development. And I've provided some examples here of various kinds of buffers and setbacks that municipalities end up creating for wetlands. So I want to spend the rest of my time speaking a little bit more about coastal wetlands in particular, and discussing a little bit or thinking a little bit more about why the Nova Scotia Wetland Conservation Policy, for example, is so concerned with salt marshes and lists all salt marshes in the province as a wetland of special significance, where, for example, you're not supposed to have a wetland alteration. So all wetlands in Nova Scotia are really important. Some of the reasons salt marshes and other marshes that are found along the coast and in coastal watersheds are important is storm protection. So they buffer against wave energy and they protect against storms and storm surges. They filter water, so they trap and filter pollutants and excess nutrients and sediments that can go into the ocean or can go into other environments. They allow for habitat for wildlife. So they're the nurseries, they're feeding grounds for commercial fish, for shellfish, and for migratory birds. And another really important function is their the carbon storage. And I'll talk a little bit more about that as well. So one of the pieces of legislation in Nova Scotia that I want to talk a little bit more about that really relates directly to coastal wetlands is actually the Agricultural Marshland Conservation Act. And it basically requires going back a couple of centuries to the 17th and 18th century, when Acadian settlers began turning the natural marshlands that we have all around Nova Scotia, but particularly around the Bay of Fundy, into dike lands. And the Acadians created these dike lands until they were expelled, and then British settlers took those dike lands over, and they continued to use them for farmland, which were quite productive, until the early 1900s, the 1920s and 30s, when the system started deteriorating. And the government, the federal government, enacted the Maritime Marshland Rehabilitation Act. And the provinces of New Brunswick and the province of Nova Scotia introduced complementary legislation in 1949 that allowed them to enter into agreements with the federal government to deal with the construction or reconstruction or restoration of dike lands and allow the federal government to oversee some of their maintenance. And that work continued until eventually the federal government actually gave back the power and ended those agreements with the provinces. The provinces continued to do that. And then that complementary Nova Scotia law, the Marshland Reclamation Act, was removed, and a new act, the Agricultural Marshland Conservation Act, was brought into force in 2000. And the focus shifted slightly from developing new marshland, so converting all of this marshland into dike land, to conserving current levels of dike land and also limiting non-agricultural development. So this is kind of really important for coastal wetlands more generally, because the minister, in establishing this new act, actually recognized the function not only of marshland and being really productive farmland, but also being really important for protecting coastal environments and coastal communities. In a statement when they released the Agricultural Marshland Conservation Act in 2000, the Minister of Agriculture and Fisheries at the time stated that by limiting non-agricultural development, we are also decreasing the chance of flood damage to commercial and residential structures built on marshlands, which can flood during severe storms and high tides. So even in 2000, there was this really important recognition that these marshlands, these wetland areas, are really important and provide really important functions outside of the agricultural land. Now, the Act defines marshland as any land that is subject to periodic tidal flooding and is designated by the minister as marshland. So it effectively deals only with coastal marshland. The core of the Act is a prohibition on development in marshland or sections of marshland, except for certain activities or development that conform with general farm practices or are necessary for the protection of marshland. So essentially, it was to protect these agricultural marshland areas for agriculture. It also allows designation of new marshland or marshland areas. It allows for an Agricultural Marshland Conservation Commission to advise the minister, the provincial minister. It allows for the incorporation of marsh bodies, and this is a huge part of the Act, which consists of owners of marshland and allows them to essentially deal with all aspects of those lands, including entering into agreements, buying and selling, activities, and setting rules and bylaws. Now, the department has recognized that climate change is posing a significant risk for these marshlands, and they are not alone in this. So the department, for example, is working with various stakeholders and experts and other governments to try to create long-term solutions prevent degradation and flooding of these marshlands as a result of climate change. But there are all kinds of projects and endeavors to try to think about, is this still the direction we want to go? Is this still an important objective? Do we want to convert, for example, some of those dike lands back into natural marshlands? How does the act that was originally, coming back from the 1950s, how does that accord with reconciliation and Mi'kmaq stewardship of the land and the Mi'kmaq relationship with the land? There's also projects, for example, the Adaptation Pathways for Dikeland Resilience Project, that's trying to explore how communities might explore different options. So, do you want to keep the dike in place? Do you want to change the location of dike? Or do you want to move dike back? So, is there a holding the line realignment or a managed retreat going on? So there's all these really important conversations happening right now on the coast and for coastal wetlands as a result of climate change and a changing coast. The final thing I just thought it would be really interesting to speak to briefly is this idea again of the ecological function. So, as I already said, the wetland conservation policy has the objective of no loss of wetlands of special significance. So there we see the salt marshes and the prevention of a net loss in function of other wetlands. And so that function piece is really important. And that's where we get to blue carbon and blue carbon ecosystems. So blue carbon is essentially just a term that refers to carbon that's captured and stored by the world's oceans and coastal ecosystems, and is really specifically focused on mangroves, seagrasses, and salt marshes. And in Atlantic Canada, we have seagrasses and salt marshes. And these blue carbon ecosystems, and specifically salt marsh, are so important because they trap carbon dioxide in their root structures and in the sediment at rates that are much more significant and faster than land forests, for example. But it's also important to recognize that right now in Nova Scotia and in other Atlantic Canadian provinces, we actually don't have a great way of dealing directly with the ecological function that is blue carbon sequestration. And blue carbon, the terminology blue carbon, carbon sequestration, doesn't appear anywhere in legislation or in policy. So there's this gap between something that's really important that we really need to be dealing with and addressing and protecting, and a lack of language to deal with that really important function. So there's really no coordinated approach to assessing individual and cumulative effects on these blue carbon ecosystems, including the salt marshes. And there's not a coordinated conservation, stewardship, or protection priority around these sorts of ecosystems. So I think that's probably where I'll leave it. I'm looking here at the time. I'm just going to flip to the last slide here and just note some additional resources that I think people might want to check out or might be interested in. So these are all available on our website. We do have two resources on provincial Nova Scotian tools, so it expands on some of the things I've just highlighted today. And we also have a guide to municipal wetland stewardship that provides lots of examples, including some of the ones I mentioned. And then there's some other blog posts and other shorter resources as well. And if folks want to check out our environmental law inquiry service, that is available as well to people who have questions about environmental law in their region. So I'm going to stop sharing now and let Richelle take over.
Awesome. Thank you so much, Mike. Yeah, so I'll share my screen. I will also keep my video off because it's quite windy here in Fredericton, where I'm calling in from, and we did have a quick power outage. So fingers crossed that everything goes okay for my presentation, but I will also keep my camera off just for the internet connection. So I will share my screen. Okay. Okay, so yeah, thank you, Mike, for setting out some of the key laws and policies that are used to protect wetlands in Nova Scotia. I'm going to be talking about how the law in Nova Scotia protects species at risk and biodiversity. And so my presentation will cover a little bit of background on species at risk and biodiversity focused law and policy. I'll talk a little bit about Canada's Species at Risk Act, Nova Scotia's Endangered Species Act. I'll look at a little bit of a case study on the Blandings turtle and how it's protected under both of those acts, and then a little discussion on Nova Scotia's Biodiversity Act. So, without going into detail, I'm sure everybody who's on the call knows that we have a biodiversity crisis. So, according to the Intergovernmental Platform on Biodiversity and Ecosystem Services, 1 million of the world's estimated 8 million species are threatened with extinction. And about a quarter of the world's species are estimated to be at some level of risk. So this is when we refer to the biodiversity crisis, this is what we're referring to. And the countries around the world have been working together through international treaties to address the biodiversity crisis for decades now. So there is some good work happening to try to reverse this trend. So in 1993, the Convention on Biological Diversity was signed, which is a global treaty for the conservation of biodiversity. So that was kind of the first international treaty that really dealt with the biodiversity crisis. The A few years later, Canada and all of the provinces and territories except for Quebec entered an agreement called the National Accord for the Protection of Species at Risk. And this, among other things, included a commitment to establish complementary legislation and programs that provide for effective protection of species at risk throughout Canada. So this was an agreement that the federal governments, along with the provinces and territories, would have complementary laws that could be used to protect species at risk. And then another kind of just large agreement that I wanted to note is the that in December of 2022, another global agreement was signed kind of as part of the Convention on Biological Diversity called the Kunming-Montreal Global Biodiversity Framework, which which set a series of goals for 2050 and then targets for 2030. And one of the targets, there's 23 targets for 2030 that all deal with halting and reversing biodiversity loss across the globe. But one target that we hear of a lot in Canada as a big focus right now is the target to conserve 30% of lands, inland waters, and marine and coastal areas by 2030. And there's a corresponding target to restore 30% of degraded lands, inland waters, and marine and coastal areas by 2030 as well. And so these frameworks have kind of spurred action. So this is an example of an international agreement that does have some, spurs action in that has spurred action in Canada and in other countries to tackle this issue. And so in 2002, Canada passed its Species at Risk Act. And the purpose of the act is to prevent species from being extirpated or becoming extinct, to provide for the recovery of wildlife species that are extirpated, endangered, or threatened as a result of human activity, and to manage species of special concern to prevent them from becoming endangered or threatened. Um, and because the federal government has jurisdiction over certain matters, and then the provinces and territories have jurisdiction over other matters, the federal act applies primarily to the areas of federal jurisdiction, which includes federal lands, aquatic species, and migratory birds. And aquatic species includes fish, marine mammals, and things like mollusks and marine plants. And so those that's really where the federal act applies. Um, there are 72 species currently listed under the Federal Act that can be found in Nova Scotia and its surrounding waters. And more information, actually, there's lots of information on those species and on more about the Act and publications can be found at the Species at Risk Public Registry. And I've included a link here on the slide to the public registry. So the Federal Act established the Committee on the Status of Endangered Wildlife in Canada, which is often referred to as COSAWIC. And this is an independent advisory body that assesses and reports on the status of wildlife species at risk in Canada. And so under the federal framework, the scientific assessment aspect is separated from the actual decision whether to list the species as at risk under the Act. And so COSWIC is the independent body that assesses the species. They publish status reports on species status and categorize them as categorize the level of risk that the species is facing. And then the governor and council, which is made up of the governor and council is the governor general's decision on the recommendation of cabinet, so of the ministers at the federal level. That's the body who decides whether to list the species as at risk under the Act. And the species that are listed in Schedule 1 of the Act. And once a species is listed under the Act as endangered, threatened, or extirpated, um, those species that are on federal lands are aquatic species or are migratory bird species. The Act prohibits killing, harming, harassing, capturing, taking, possessing, collecting, buying, selling, trading of those individuals, along with the destruction of their residences, so nests and dens. And so there's this general prohibition that protects certain species once they are listed, but the species have to actually be listed to get that protection. The listing also triggers certain requirements of the relevant minister. And so one of those requirements is to prepare a strategy for the plan to protect and recover the species called the recovery strategy. And a key piece of the recovery strategy is the identification of the species' critical habitat. And the critical habitat is the areas that are necessary for the species' survival or recovery. Um, this is really important because habitat loss is one of the number one drivers of species loss. And so to protect the species, we have to protect their habitat. And so once critical habitat is identified in a recovery strategy, the Act imposes then certain legal obligations on the responsible minister to ensure that the critical habitat is protected. So there's a requirement to publish an action plan in the species registry with the proposed measures to protect the critical habitat. If the critical habitat is on federal land, or if it's for an aquatic species, there's a requirement to issue an order to protect the critical habitat in those areas that it's not already legally protected. For migratory bird species with critical habitat that's not on federal land, there's a requirement for the minister to recommend that the governor and council make an order to legally protect the remaining portions of unprotected critical habitat. And then there's a requirement to report on the steps taken to protect critical habitat. And so we typically see that critical habitat is legally protected when it's in a national park or part of federal land. When the critical habitat is on provincial land or private land, there are tools under the Act to protect that habitat, but it's less straightforward and they are less frequently used. I would say they're rarely used. And so that's where the federal government relies on the provinces and territories to have complementary legislation to fill those gaps. And so in 1998, Nova Scotia passed its Endangered Species Act. And the purpose of the act is similar to the federal act, just to provide for the protection, designation, recovery of and other relevant aspects of conservation of species at risk in the province, including habitat protection. And the Minister of Natural Resources in Nova Scotia is responsible for the administration of the act. The listing process at the provincial level is a little different than at the federal level. Under Nova Scotia's Act, there's a species at risk working group that assesses the status of at-risk species in the province and provides the minister with a categorized list of species at risk for the purposes of the Act. And then the minister will is supposed to list those species that are recommended from the species at risk working group under the Act. And similar to the federal act, for species that are listed as endangered or threatened, the act prohibits the killing, injuring, disturbing, um, trading of those individuals of the species, along with the destruction or interference with their dwellings. So again, the nests and dens. So once the species are listed, they automatically get that protection in Nova Scotia. And this would apply to private lands as well as provincial lands, unless there's a permit issued. Um, and once the species is listed, the Act also requires the minister to take certain measures to protect the species, including to appoint a recovery team and prepare a recovery plan within 1 year of the listing of an endangered species and within 2 years of the listing of a threatened species. The minister is also required to identify areas to be considered for designation as core habitat in the recovery strategy. So similar to the federal government, there will be areas that are identified as core habitat in the recovery strategy, but they don't actually get legal protection until they're designated under the Act. In Nova Scotia, there's no requirement to designate those areas. There is a requirement to prepare a management plan within 3 years of the listing of vulnerable species, and recovery plans and management plans are required to be reviewed every 5 years. And so core habitat is defined in the Act as specific areas of a habitat that are essential for the long-term survival and recovery of endangered or threatened species and that are designated as core habitat under the Act. So the minister, once core habitat has been identified in a recovery strategy, the minister does have the authority to designate areas as core habitat. And then once those areas are designated, the minister can create regulations to restrict certain activities in those areas. But in the 26 plus years since the Act has been enforced, the minister has never made a core habitat designation. So this is a common criticism that folks have of how the Act is administered is that the habitat isn't actually getting protected oftentimes. With there is a link here that I provided as well. There's a species at risk recovery update webpage. So there was a court challenge several years ago over the minister's failure to fulfill its legal obligations to develop recovery strategies and identify areas for the potential designation of core habitat. And the Supreme Court of Nova Scotia determined that the minister, because the Act requires the minister to do these things, that is a legal obligation. And so that decision spurred some action. And so this web page provides an update on kind of progress that's being made. And so I just wanted to quickly look at the Blanding's turtle because it's an example of a species that is listed under the Federal Act and the Provincial Act. And so we can kind of see how those acts can work together. There's three small populations that are found in southwest Nova Scotia with an estimated total population of 200 adults. So this is an endangered species, both federally and provincially, so it is at risk of extinction. And human alteration of nesting habitat is one of the primary threats to the species. And another reason I chose this species for Wetlands Appreciation Week is because this is a species that uses wetlands as part of its life cycle. And so in 2000, it was listed as endangered under the Provincial Act. In 2006, it was listed as endangered under the Federal Act. And in 2012, the federal government published the recovery strategy, identifying 5 critical habitat sites, which do include a mix of federal, provincial, and private land. And in 2014, The area of critical habitat that's part of the Kejimkujik National Park of Canada was a description of that habitat was published in the Canada Gazette, which then provides protection from the destruction of that habitat. Um, in 2020, the federal recovery plan was adopted by the Nova Scotia Department of Natural Resources as its recovery plan, along with the areas that have been identified as critical habitat. And then in December of 2020, the federal government published an action plan that it doesn't really provide much detail on how the areas in the province that aren't currently protected will be protected, but it essentially says that the federal government will work with the provincial government to determine um, habitat protection needs and come up with a plan. So as of right now, for the Blandings turtle, there's habitat protection in the national park, but for the other areas, there's no protection unless they're part of a provincial park or another private conserved area. And very briefly, I'm just going to wrap up with a little bit of information about Nova Scotia's Biodiversity Act. So this is a unique piece of legislation in Canada. In April of 2021, Nova Scotia was the first jurisdiction in Canada to enact a law that's dedicated to the preservation of biodiversity. Um, there was a previous version of the act that had been tabled and making progress in the legislature, but there was a strong opposition campaign. And it resulted in a pretty watered down version of the act. But we still have a Biodiversity Act. The act acknowledges that biodiversity is essential to healthy and productive ecosystems and is therefore essential to human well-being. Um, and it acknowledges that current laws in place to protect the environment and species at risk don't address all aspects of conservation and sustainable use of biodiversity. So one of the reasons why the act was enacted was to address invasive species and be able to create regulation, to allow the minister to create regulation for the management of invasive species. We haven't seen that happen yet, but that was kind of the thinking at the time. Um, and if you are interested in kind of the more of the history of the Biodiversity Act, we do have a couple blog posts on our website that go through it in more detail. So with the kind of watered down version of the act, as I said, we're left with two mandatory time-bound requirements of the Minister of Natural Resources. The first is to publish a report on the state of the province's biodiversity within 3 years of the act coming into force, and every 5 years thereafter. And the second is to initiate a public review of the act within 5 years of the act coming into force. And so last fall, a little bit about a year late, but it was published nonetheless. The Department of Natural Resources did publish a state of biodiversity story map. So not a kind of traditional report, but it is a good resource. And it's available at the link that I've shared here that goes through the state of biodiversity in Nova Scotia and some initiatives that are taking place to conserve biodiversity. And so that fulfilled the first requirement. And then the second requirement is an opportunity, I guess, to ask the department to look at reviewing the act, how it's being used, and potential opportunities to strengthen it, which the act requires to be commenced this fall. The act also requires the minister um, to establish and maintain inventory, status assessment, and monitoring programs that the minister considers are necessary to assess the state of biodiversity, um, and to establish mechanisms to share biodiversity-related data. But there's no timeline for these requirements in the Act. And then lastly, the Act does have some discretionary, so these are optional powers that the minister can use that they haven't used yet, but they're there in the Act that the minister can um, do things like set certain biodiversity targets. The minister can enter agreements with individuals, businesses, or other governments respecting the conservation and sustainable use of biodiversity. And another key tool is that the minister can establish biodiversity management zones on Crown land with the approval of the governor and council, or on private lands with the agreement of the landowner. And if a biodiversity management zone is established, then regulations can be put in place that can regulate the activity within those areas, including can do certain things to prevent and manage invasive or alien species, which was one of the key reasons why this act was developed in the first place. But again, we haven't seen this happen yet. And so that is the end of my presentation. We have a few minutes left. Mike mentioned some resources. I also have the resources that he mentioned, plus a couple other he's here with links to our resource library. And so I guess I can leave that up for a little bit. And Mike, if you want to take any questions, or we would welcome to hear feedback from folks on the other types of resources that might be helpful relating to wetland law and protection.
Yeah, and I think I forgot to mention like if you have questions, feel free to post them in the chat. You can unmute yourself and ask those. I'm also going to post a link to the Ecology Action Center's website, which has some other Wetlands Appreciation Week events going on until the end of the week. So I would encourage people to check those out as well. There's lots of really great events going on all week.